County Tea Party. We have with us Chuck Meyer today, and he's run for the Appeals Court, District 9 over in Beaumont. It's Thursday, December 19th. And with me are Larry Rogers, Bob Bagley, and David Smith. So Chuck, as we discussed a few minutes ago, thanks again for coming in, especially on short notice and completing your questionnaire.
I appreciate you working me in.
You betcha. So as we talked about, if you want to get us started with up to 5-minute overview, and then we'll just start around the table with Q&A after that, and then wrap it up.
Sounds good. Well, as you said, my name is Chuck Meyer. My formal name is Charles. My family does not call me Chuck. The ones, my parents and my sister, they call me Charlie. So I've had multiple personalities, but not anything you need to worry about. In the vein of multiple personalities, I started out my career as an engineer at the Pentagon. I have a degree in systems engineering from the University of Virginia, a university that was founded by Thomas Jefferson. And when I went there, I became quite the fan of the man. Among other things, he was the founder of the U.S. Patent Office, where I eventually ended up after my civilian tour of duty at the Pentagon, where I was designing computer systems to let the nation's leaders know when we were under nuclear attack. And thankfully, for a variety of reasons, my designs were never tested, which is probably a good thing. I moved to the Patent and Trademark Office, where I was in a quasi-judicial position as an examiner. I made decisions on behalf of the federal government as to whether or not an inventor was entitled to a United States utility patent. And the area of technology that I was involved in was the area of computer software implemented inventions. I did a lot of work in the well borehole logging technology area as a patent examiner, as well as 3D seismic prospecting tools that were implemented in software. And I also had on my docket cash registers, games, and a few other things. It was an interesting part of my career, but it trained me to have the discipline to progress cases quickly, because there's only so much amount of time you could spend on an individual patent application before you had to move on to the next one. And the seat of the Court of Appeals is very much the same way. Let me give you just a little bit of a condensed, and maybe I can expand this later in the 5 minutes at the end, view of my career after the patent office. I went to law school at night while I was a patent examiner. I went from there to be a judicial law clerk for a federal judge, who actually sits now in San Antonio, but at the time he sat in Honolulu, Hawaii. He was a very good mentor to me. I was his tail when I left Hawaii as I arrived, because I rarely saw the light of day working for Judge Ezra. But he trained me well to go into private practice. I was with a large international law firm where I did federal bankruptcy law, and also did patent law, corporate bankruptcies and restructurings. Then I went to the Ohio Supreme Court for a year and worked for a justice there. So I saw firsthand the highest Supreme Court of a state, how a justice handles reviewing the law and applying the law to the cases before it. I've been very privileged to have worked for 2 judges in my career, and I think that is something that distinguishes me from my opponents. Another thing that distinguishes me from my opponents is that I'm a part-time prosecutor currently in Hardin County, which is one of the 10 counties in the district. I went to work for Mr. Sheffield, the district attorney, I believe in 2014, maybe a little earlier than that, on a volunteer basis. I wanted to write appeals for the district attorney. And after I wrote about 2 or 3 of them, he says, you know, we can pay you a small amount for doing this. And I said, well, I won't turn down money. And it really is not a great sum of money, but it enables me to give something back to the people of the state of Texas, someone who thinks about what the case law should be in the context of trying to keep criminals in jail that have already been convicted. Or sometimes we were required to respond to writs of habeas corpus before the state's courts, and that is after they've been convicted and after their appeals have run through. I've been married to my wife for 36 years. I'm the former chief legal officer of BlackBerry, so I have been a chief, unlike many of my opponents, if not all of them. I also was the head of BlackBerry Europe on the business side, so not only have I been an engineer and a lawyer, but I've also been a businessman of a publicly traded company, and I had 102 people, more than 100 people, let's say, underneath me when I was head of BlackBerry Europe, and I had 12 people in my legal department. I wore both hats at that time, both chief legal officer and the head of BlackBerry Europe in England. I have a law degree from the American University. I have a master's in operations research from George Washington University, and I have a law degree from the University of Oxford, England, which is an LLM. It's reputed to be the toughest LLM in the world, at least according to their website. So I believe my time is up. I'd be happy to answer questions at this time.
All right, thank you, appreciate that. Perfect timing. Under the questionnaire, general, and the first question, why are you seeking this pension? What 3 primary goals do you have in mind? Number 2, you mentioned that your cause outside of the role as a justice is to ensure that we continue to manage the judiciary's take of the state's budget so that we are spending taxpayer money wisely. And that's great, and that's what we're all about primarily. You also said that I would like to see state open records statutes applied to the non-judicial aspects of the courts of this state.
Yes.
Can you explain what you mean by that?
Yeah, when I ran previously for the 410th District Court, I tried to get information about how well the judges were functioning with their caseload. And it was given to me, but not all of it was given to me. And there's no provision under the Open Records Act to ask a court for records that aren't judicial, unless the law has changed and I missed it since 2016. I think that's a mistake. If a court is not acting like a court, in other words, a judge has to have some confidentiality associated with the case before it. You know, his notes during a jury trial or during a bench trial should be confidential to that judge. But if a citizen wants to know how their taxpayer monies are being utilized by the various courts in the county, and I'm talking mainly about trial courts, but it applies to all the courts throughout there, I should be able to file an open records request or FOIA request or whatever you want to call it, and have them provide me with the same data they provide to the judges during the judges' conference. And also, I would like to have seen the data that justified the position for the new 457. I have a little bit of statistics in my background, and I just would like to know as a citizen that it's a legitimate claim that we're now having to pay for another court. I don't deny that we need another court here in this county, but I just would like to see the statistical underpinnings for the decision as to why we have another court.
All the candidates think that they need it.
I'm sorry?
All the candidates that are running for that think they need it.
Well,
But so they don't have that available now where you can go to the administrative judge, who is at Olinwood, does he not, or who's the court?
Well, I'm sure you can go to him, and I'm
Yeah.
sure he'd give it to me.
Mhm.
That's not the point. The point is I should have the same right to a public record from a court as I do from any other governmental institution.
So it should be like posted online where you can go access it.
It doesn't have to be posted online, that'd be nice.
Mhm.
I just want to, I want to have the ability to submit a request and not have it returned to me saying that it doesn't apply to the judiciary. And that is the basis
okay.
by which a judiciary can. And again, I haven't done research on this in 4 years, 3.5 years, so if the law has changed, please forgive me, but my sense is that the law has not changed because most people can get what they want because people are willing to comply. But compliance is not the issue. The issue is having the unfettered right to those records, just as with any other government institution.
Okay, Bob?
A huge issue in Montgomery County and throughout the state of Texas, I guess nationally as well, is civil asset forfeitures and the lack of due process that comes along with that. Can you explain your feelings on civil asset forfeitures and,
Yeah, let me preface my remarks by saying this is not something that a judge can necessarily do anything about, other than if a case comes before the court and there's an allegation of a lack of due process, and the legislature has not explicitly said that a different standard applies in that circumstance, then maybe a judge could do something about it. But by saying that, I'm potentially creating bias for me down the road to sit on a case in which that issue would occur. And I'm willing to take that risk to answer your question, but be aware that when I answer any of your questions, I don't want to get in a situation that a judge in this county got into by making a remark about sex offenders that came back to haunt him later on and being removed from cases. I would prefer the legislature deal with this issue straightforwardly so that a judge sitting in the court doesn't have to impose his or her bias as to a particular situation, but make it very clear that in Texas, at least, we can't do much about the federal law, but in Texas at least, these are the criteria and this is the due process that is to be afforded someone whose assets are taken away from the moment that they are arrested or shortly thereafter, with sort of a minimum amount of due process involved in the taking of those assets. I think, I want to be careful how I say this, but I've been on the public record before, I think I put that in the response, that someone needs to make a claim, maybe not under the US Constitution, but under the Texas Constitution, that this is a taking of property without due process. And I'm confess I haven't read the cases in this area. Maybe there's been a case out there where a court has shut it down, but it seems to me that this would be an area that would be ripe for a Texas constitutional law claim, point aside the federal constitutional law claim. And that should be the way we go about it, if I were in the business of litigating these claims before the courts.
okay, so let's say, for instance, that a case like this did come to your court and you saw that there was an issue that needed to be taken to the legislature.
Right.
Would you as a citizen, not necessarily as the judge, but you as a citizen be willing to put together documentation for it to be forwarded to the legislature for them to possibly put it in a bill?
I think a better way of doing that would be to write a dissent or a concurrence pointing out the issue and say, it's unfortunate that we have to rule this way in this case today, but it's a result of the legislation that is before us. If you want to see a different result, then the state legislature needs to amend the legislation to provide X, Y, and Z. I'm more than happy to state that I would do that in a concurrence or a dissenting opinion. But I don't think it's appropriate for a judge to interact too much as a member of the public. I would like to think that I'm going to have more than enough things to do as the Chief Justice of this court, if I'm selected and elected, than to be an activist for a very worthwhile cause, but a cause nonetheless. Just as I wouldn't necessarily be an activist for other causes that I believe deeply in.
I'm not saying that this is a cause, I'm just saying that you're sitting there as a judge
Right.
and you're seeing not necessarily justice because the laws aren't right.
Right. The most that I would commit to is I would make sure that if it bothered me to the extent that I would want to do what you're suggesting, that at the very least that I would put it in the opinion that goes to the litigants, that the reason that I don't want to be an activist judge, so the proper place for resolving this in a better way, in my personal opinion, is for the state legislature to make it clear that change the standard for due process in these explicitly in the legislation, and provide limitations on which you can actually have civil forfeiture.
Okay, thank you.
But having said that, you know, some of my friends that are in the business of being prosecutors don't like that because we bring in a ton of money through the civil forfeiture process that goes to fighting crime. To that I respond, you can't violate someone's constitutional rights or potentially violate their constitutional rights to fund your crime fighting program. That's something else the state legislature or the local communities need to step up and do.
Not too long ago, a visiting judge in a case that had interest in Montgomery County overturned the Texas Open Meetings Act. And then right before that, the visiting judge convicted and subsequently overturned Governor Perry's use of his veto, threatened to use his veto. So do we have a problem with local judges passing off, politically difficult decisions onto these unelected, usually defeated visiting judges?
Well, just as I'm an assistant district attorney for Hardin County, I am still an assistant district attorney for the state of Texas. And the district attorney is a district attorney in the state of Texas, and the judges are Texas judges. So in an ideal world, it shouldn't make a difference if you get a visiting judge from Liberty County or one of the neighboring counties here. I'm not so sure about Harris County, but it should not make a difference. I'm concerned, and this is going to be an incomplete answer, so you may have to ask me an additional question, but I'm familiar with the first case you're talking about. I'm not familiar with the second case. But if you're talking about the Court of Appeals, the Court of Appeals rarely brings in visiting judges. What they do is they will transfer a case to another district. I have a greater concern there than I do at the trial level, because you potentially are going to have a panel of 3 judges from another judicial district deciding a matter that involves businesses or people or criminals even. Not that criminals aren't people, but that potentially could have, that did not vote for that panel. And I think the citizens should be entitled to have their cases heard by courts that are voted upon by the people who are appear before them. That concerns me. Now, there aren't many transfers that I am aware of, but there have been some transfers out of this court. Sometimes it's hard to discern whether it's for reasons that it's a difficult case politically for some of the judges, or whether it's just there's so much press of business, another district doesn't have as much business. It's a good thing to transfer it so that justice is served expediently. But one of the things that I want to do, if I become the Chief Justice, is to make sure that we're transferring cases for the right reasons, and that it should be a rare occurrence.
You expressed a concern about the appeals court transferring
Yes.
cases, but isn't that no different than?
It's different because you're transferring cases from a court. And yes, we can say we have individual courts in this county, but we really have individual judges that have numbers associated with them. And transferring it from one state trial judge to another, we weren't transferring it from a Montgomery County numbered court. District court, we were transferring it to a visiting judge sitting in that court. When the Court of Appeals transfers a case, it transfers it to another court entirely. And they're similar, but they're also, I'm more concerned when you transfer cases from one court to another. If this matter had been transferred out of that court into a court in another county, that would be the same, and I'd have greater concerns there. But we elect judges in this state to be independent of political concerns, and I think, well, we're supposed to be,
It's not working so well in Harris County.
But no, it isn't working. If you're on the other side of the political spectrum, it's not working well in Montgomery County, some would say. But
It's getting better, but
It's, I have no proposal to resolve the trial court level, and quite frankly, haven't really thought about it. But I do have a proposal for resolving a very similar issue, and I think a much more troublesome issue at the Court of Appeals.
Okay, I've got a series of questions and then I'll bug it. What's a STEM degree? You mentioned.
Science, technology, engineering, and math.
Okay.
Put that clock on.
Okay.
For me.
That's my engineering degree and my operations research master's degree.
Okay, gotcha. You said of course, you referenced appellate prosecutor for Hardin County several times. How many cases of these have you handled before the Ninth Court?
All of them are before the Ninth Court, and I think 13 within the past few years.
Is that the total one?
Yeah, I mean, it's very much a part-time gig.
But you're familiar with them and the process and vice versa?
Oh, yeah.
Okay.
All too familiar. So, the biggest problem when you're an appellate attorney is trying to navigate the computer systems. And I finally have that down. So,
Right, okay. You said, please list the key difference between you and your opponents.
right.
There's a couple of questions there, answers. You said you're unabashedly and unapologetically pro-life. Do you believe in capital punishment?
Yes,
Okay.
if the state legislature has prescribed it. It's not my position to say whether or not capital punishment should be applied. And the good news is, to some degree, this court doesn't get involved in capital punishment decisions, although I did have one case that involved an evidentiary issue that went to this court that was a capital case. But for the
Does it
most
go straight from the trial to the Court of Criminal Appeals?
Well,
Capital?
If it's a capital case, after conviction, it goes to the Court of Criminal Appeals. But in this instance, it was during the course of a trial, it was what's called an interlocutory appeal during trial on an evidentiary issue concerning DNA testing. And it was a very interesting issue, and it was probably the longest brief I ever wrote for the district attorney. But that went to the Ninth Court of Appeals, even though it was a capital case, because it wasn't deciding the capital punishment aspect of it.
Mm-hmm. Okay, and you also made in your comments there under Part B, you said you started your professional career as command and control communications engineer at the Pentagon,
Right.
which was in your opening, and then you kind of went on to say your engineering mindset is what separates you from your opponents, and you indicated you're much more analytical than most of my opponents. That's a pretty bold statement.
You know, I've only seen 3 of them on the campaign trail,
Mm-hmm.
and I've only, I'm a little biased. I don't believe trial attorneys have the same skill set as those of us that have been engineers. I'm sorry, when in law school, the engineers had a particular way of looking at the law that the other students just didn't. And the best way I can describe it is we're more analytical. And that may sound egotistical, but as Michael Brady says, it's not bragging if it's true. So, but my point about this is that when you have training from various disciplines, either having been a businessman or having been trained as an engineer and worked as an engineer, and having been a lawyer, you bring different skill sets to the table that I assure you my opponents don't have, based upon what I can tell about their background.
Mm-hmm.
I don't believe any of my opponents have managed over 100 people. I don't believe any of my opponents have designed computer systems. I don't believe, and that doesn't directly translate into being a better justice, but it is a certain mental discipline that allows you to logically think through issues in a little different way than your average trial attorney.
Okay, one more quick one, and then turn it back over to these guys. You said most people don't know about this court. And,
Yes.
and the average person really doesn't. I mean, I don't think they know the difference between the trial court, appeals court, and the court of, I used to call them court of criminal court of appeals, but.
And the Supreme Court.
Yeah, and the Supreme Court, actually, which is separate. So can you explain for the average viewer
Sure.
what the difference is between those courts and how they interact?
We are the only state in the country that actually has two Supreme Courts. We have the Texas Supreme Court, which handles all non-criminal matters, and we have the Court of Criminal Appeals, which handles criminal appeals that are discretionary except in death penalty cases where it's mandatory. So if you're convicted of a capital crime and you're punished with the death penalty, or assessed the death penalty as your punishment, then that appeal goes to the Court of Criminal Appeals as a matter of right. Then beneath these courts,
Straight from the trial court.
straight from the trial court.
Okay.
Then beneath these courts are the 14 courts of appeal. And we here in Montgomery County sit in a 10-court district, 10-county district. This court hears criminal appeals from all the district courts and the various types of county courts, as well as civil appeals from those courts as well. And by civil, I don't mean just contract disputes or tort claims, but I also mean family law matters and potentially probate matters too. And then beneath those courts are the trial courts, which the ones that appeal to the courts of appeal, the numbered courts of appeal, are and it depends on where you are in the state, but it's definitely the district courts within that district, the constitutional county law courts, the county courts where there's a single county judge, and I think there's other types of county courts so in Montgomery County, we have county courts at law, appeals from there. For the most part, we go to this court, but the bulk of the cases that go to this court are from the district courts. And so the district courts here in Montgomery County, you would appeal from there. And then below them are the JP courts. And the JP courts in some cases, you can appeal from a JP court to one of the trial courts. But I'm not a trial lawyer, so don't get me into the weeds on that because I won't get it right, I'm sure.
All right, Larry.
So you're not a trial lawyer, so have you had how many jury trials have you had?
I have not had a jury trial. I'm not a trial lawyer.
In your experience, and you're a prosecutor now, so in all of the time that you've been practicing law, could you give me a percentage-wise, criminal versus civil?
Sure. I am a general counsel type, and I'm also a very part-time prosecutor. So I would say that my criminal law experience over my career, it's hard to measure, but I really became a prosecutor in 2014, so I've been a lawyer for 30 years, so that's 5 years out of 30, so that's 1/6. That's 16%, so now of that, I would say maybe 10%, so 1.6%, potentially. But in terms of the last 5 years, it's a higher percentage. Thankfully, as the chief legal officer of BlackBerry, I didn't have to deal with any criminal issues. Although I will say, and you might say this is criminal law, when I was at Compaq, I was a lawyer at Compaq where I was an intellectual property counsel, and we all participated in compliance training. And we had to know all the various criminal laws that could apply to a corporation and explain it to all the employees when we did trainings to all the employees. Other than that, that's not where I have a lot of criminal law experience.
Yes.
But I have appellate criminal law experience.
Bob?
We have issues here in Montgomery County with, or in the past anyway, with judges not being in their chambers or not being on the bench. on Mondays and Fridays especially.
Yes, I remember someone referring to the fact you can roll a bowling ball down the corridors.
Yes, and nobody would hear it.
Yes.
So, what's your work ethic? I mean, what are you looking at? Are you looking at doing this as a full-time position, 40
absolutely.
hours a week, Monday through Friday?
No, it's more than 40 hours a week, because the Chief Justice position in particular, you have to travel, you have to sometimes give testimony before the state legislature, sometimes you're meeting up with all the other Chief Justices to work on the judiciary budget for the Courts of Appeals. You are the Chief Judge and you have to assign the opinions. You have to create the panels, you have to work closely with the clerk of the courts. I'm planning, if I'm elected, to actually get an apartment in Beaumont and commute probably Sunday night over there and come back Thursday night or Friday. We do have the ability to use a courtroom here in Montgomery County, and the court sometimes sits there if there's enough cases from Montgomery County. I made reference earlier on about the fact that this is, in some respects, piecemeal work, like a factory. I think I put that in the statement as well. And we are mandated by the state to conclude as many cases as we take in. And right now, the run rate is 500. As Montgomery County continues to grow, considering it's the biggest county in the district, and we start seeing more civil cases being tried here, the criminal cases aren't going to go down, they're only going to go up. And I think that the civil cases will also go up. And there isn't enough volume in this court currently to justify a fifth justice on this court, but someone needs to be looking at that, and looking at statistics, and helping the judicial redistricting panel decide whether or not this court is entitled to a fifth justice. I don't think my work ethic has ever changed from being a startup lawyer for a high-tech company where 50, 60, 70 hours a week was the norm. When I was a young associate before my BlackBerry days, we had to bill $2,000 hours a year, and I'm not that efficient, so 2,000 hours doesn't mean 2,000 hours working on things, it means more than 2,000 hours working on things. And that's a 40-hour work week with 2 weeks of vacation. I just don't believe that my work ethic has changed that much. I'm a little slower, but not that much from those days. And I view it as not the number of hours you put in, but are you getting the work done? And if you look at the 500 cases that the court currently has to dispose, that means that each justice has to dispose of 12 cases. I think the clerk told me 12 cases a week. I have to go back and review that math, but 4 judges, maybe it's a month. And that may not seem like much, but when you're writing opinions on those cases, you have to want to write. You have to like the process of writing, because it's a lot of writing and a lot of reading. I've talked to 2 of the justices on the court, and they said, just be aware, it's a lot of reading and writing. It's like being in law school again, or being a law clerk for a federal judge or a state Supreme Court justice, which I did earlier on in my life. And I must say, those were the 2 best jobs I ever had, because I was able to write about the law, think about the law, write about the law, and support a judge applying the law in a meaningful way. And that's what I want to do, except I want to be the judge that's applying the law. Does that answer your question?
I got kind of 2 questions. You worked at the Pentagon, you patent office, RIM,
Right.
compact.
Yes.
So when did you hang up your shingle to become a,
When did I become a lawyer?
no, when did you, you were a corporate attorney, so at
Yes.
some point you had to make a transition in which you left compact, or
Oh.
you created your own firm and.
Right.
independent
I created
businessman.
my own firm initially in 2012. I worked with a friend of mine at Compaq. We formed a little 2-man firm. But I That didn't work out for reasons that I won't go into. Let's just say we had a parting of ways. And then I hung out my own shingle briefly over in Lumberton when I was running for Congress. And then I went into the Mr. Sheffield to write, the district attorney for Hardin County, to write the appellate briefs in the 2013-2014 time frame. And then I was hired by a large partner-only firm called Fisher Broyles, which was off the, not off the grid. It was a law firm that was very virtual. We had lawyers and partners in every city, and we worked off a shared services model. And then I went back to my own private practice in 2015, and then I took some time off when my middle daughter became very ill, and spent some time in intensive care and hospice care, and graduated from hospice care in a good way. And I dedicated, I would say, 95% of my time to my family during those times when I wasn't practicing much law.
Second question, I was at Commissioner's Court one day, and a district attorney stood up and talked about the exploding felony filings that we've experienced with Montgomery County, like 5 years up 50–60%.
Right.
And then we had the incident where they ran out of public defender's money in Montgomery County. So what's going on as a citizen of Montgomery County, and hearing these appeals?
I was not aware of that second thing that you told me just now, that they'd run out of public defender money. I don't know what's going on. I know that for a number of years we had the highest number of DWIs, I think, of any county in the state. I trust that our DA is doing everything he can to put people in jail and keep them in jail for the amount of time that they deserve, and to try to make sure that that process is as efficient as possible. We live in a society that's becoming increasingly difficult to police. And if we think we have it bad here in Texas, there are many other places in the United States that are a lot worse. Not that that's a justification for inefficiency, which I'm not saying that Mr. Ligon engages in, but it's just, we have to pay for the prisoners in jail too. And I know Sheriff Rand does a very good job of trying to run the jail pretty tightly, and there's not money wasted as far as I can tell as a tax basis. But if you're talking about the problem with the need for public defender money is, if you don't give someone a fair trial with adequate counsel, and we could debate forever what adequate counsel is, and they make a successful claim of ineffective assistance of counsel, one or two things can happen. You're going to have a long series of appeals that's going to cost the state even more money, or a criminal who otherwise should be in jail is let free. Neither of those two alternatives are attractive to me. That's not to say that we should throw money at the public defender's office. We can't solve problems by throwing money at it, but by the same token, we can eliminate a lot of problems by not starving them. And it's a question, I think I put in my response, the question, do you want to pay now or do you want to pay later? Or do you want a criminal potentially to go free?
Okay, in the Court of Appeals, District 9, you said about 500 cases from what the
Yes.
clerk told you a year.
Yeah.
Does that court, appeals court, do they get to choose which cases they take and not take?
No, that's
what you see is what you
There's
get.
no discretion, unlike the Texas Supreme Court and the Court of Criminal Appeals on everything except death penalty cases. This court takes what comes in. And some of it you can dispose of very quickly because there's no jurisdiction or it can be dismissed. So some of those 500 cases you can get rid of, but still you have the rest of them you can't.
And you touched on this a little earlier. There's, the other courts can, if they are, have an overload, they can give
I don't know what the exact mechanism is for transferring court cases. I do know that this court does not have enough room to take in cases from others. And if there's going to be any transfer made, it's most likely going to be from this court to another court in order to get this big pile of paperwork done, basically. I presume that there are ways that another district could bring a case into this court, maybe on a trade, you know, we want to send you this case, but we'll send you this case. So there's a one-for-one exchange. I don't know. I didn't delve into that with the other justices. I don't know the exact mechanism for the transfer.
and
I could just assume that that's the way it works.
what's the good and bad of that?
If a transfer is made for political reasons, I have a problem with that. If the transfer is made in order for the cases to be decided, I have less of a problem with that because, as I mentioned before, we're all, if I get elected, I'm a Texas justice of a court of appeals. I'm not just a justice of the Court of Appeals. I am a Texas Court of Ninth District Court of Appeals justice, but I can be on panels in other jurisdictions. What I'd like to see, and again, I don't know if this is possible, because, but if you're going to send a case out, maybe it'd be better to bring in justices from other districts rather than send it to one district. I don't know if that's possible. I haven't looked into it until tonight. I haven't really thought that much about it. But I do have a concern in terms of the downside of, if you're a small business person in Montgomery County and you have a contract with a major Harris County oil producer, and you have to sue them for breach of contract because they're not abiding by the contract, they're not paying you. And there's an error at trial that the trial judge makes. And you appeal the case to the Ninth Court of Appeals, and you, the small businessman, you're practically going bankrupt because of the cost of litigation and the fact that you have to appeal the case. And the court looks at its list. At the bottom of the list, the 501st case is your case. They transfer it to Harris County, where this corporate entity exists. I think that you're not getting the benefit of a panel of justices for whom you voted for hearing that case. It shouldn't matter. It absolutely shouldn't matter. But if the reason that that case was transferred was that it was toxic to the justices on this court, that's a problem. If it's the reason it's transferred is because the Harris County, one of the Harris County numbered courts of appeals had room in their docket for it, I'm a little less concerned about it. But the only person that really knows the reason why these cases are transferred, there are two people. One, the clerk, and two, the Chief Justice, and maybe the other justices, other three justices on this court. But other than that, who knows why these cases are transferred? But as I said, I think I said it before, we have a very, very, very good Ninth District Court of Appeals. And my plan is not to change anything dramatically. The train runs on time, all the stops are hit, and it's done within budget. So why change a system that operates that way? And so my concerns are really at the margin.
Okay. Bob?
Do you know what the makeup is of the staff for the Chief Justice?
I met 4 of them. And this is the staff for the court. I met the clerk, I met 2 deputy clerks, and I met the security officer. And each justice is assigned 2 briefing attorneys or law clerks, lawyers that write drafts of the opinion for the judges to review. And I don't know how much more staff they have than that. I'm sure they do, but I just didn't have the time to meet everyone when I went over there, and it's something that I hope to learn more about before election day, certainly.
So when you're off up here, possibly in court or in Austin or traveling, is there enough work for all of these people to continue on without you being there?
There's too much work. I mean, the clerk does not roll out of there. I mean, she tries to roll out at 5 in the evening, but I've witnessed where she's been there past 5, and I've heard from others that that's not a rare occurrence. My biggest concern, quite frankly, about the staff is they're about ready to retire. And my biggest fear is I become the Chief Justice and I get like 10 resignations or whatever.
All new staff?
And the staff needs to be retained because they've done a good job. And they've done it without pay raises. When the judicial salaries went up for the numbered courts of appeal, that year there were no increases in anyone's salary.
Not even cost of living?
I don't believe so. I believe that was the deal that was made. That in order to provide a salary for the justice that brings people in that have a little bit more expertise than someone straight out of law school. Judicial salaries are way below what a partner in a law firm would make, for the most part. And it's a nice salary. The Chief Justice salary gets a little, I think, a $5,000 bump because of the additional duties besides being a justice. I think a justice's salary is $158,000, which is certainly less than what our county attorney used to make here. But that's not the case anymore, I know. But it's more in line with what the county courts of law judges make and the district court judges. So I think it's a fair salary. What I hated to hear was that they had to either increase the judicial salaries or increase the staff salaries. And that's something that I really hate to see, because it's the staff that can make you or break you.
Mm-hmm.
Yes, the justices can make or break you, but there are 4 justices and they sit in 3-judge panels.
Okay, Dave, you got a real quick one?
No, fine.
All right, would you like to take up to 5 minutes for closing?
Sure. I'd like to thank the Montgomery County Tea Party for this opportunity for fitting me in today. As I mentioned during the course of the questioning, I was the chief legal officer of Blackberry for a number of years. That is really where I developed my core expertise in being able to assess readily the legal implications of the actions of the company and be essentially like a soccer goalie in goal, defending the company from the shots on the goal. I've been a technology lawyer for a number of years. I'm a patent attorney, and of course, because patent law is federal law, I will not see any cases, most likely in the Court of Appeals. Although if there's a contract dispute over a patent license or other intellectual property license, theoretically it could come to the Court of Appeals, but that's highly unlikely. My main expertise for this court is the number of cases I've handled for the district attorney's office in Hardin County. I know this court system. I've appeared before it on paper. This court holds very few oral arguments, and they rarely hold oral arguments in criminal matters. It really is an operation where you are spending your time as a justice, reviewing the law, reviewing the facts of the case, reviewing the errors that are alleged by the appellant, and then writing an opinion that reflects the view of 3 justices on the court. It's something that I think I'd be very good at. I have, as I mentioned before, I was in a quasi-judicial position as a patent examiner where I had to apply the law to make decisions as to whether someone had a patent. When I worked for a federal district court judge, I drafted opinions in summary judgment, or for summary judgment orders and other areas. And certainly when I worked for a state Supreme Court justice, I also drafted opinions. It's what I like to do. I like to write about the law. The only other thing I'd like to point out is I believe that I'm different from the other candidates in that I think we should have more focus on this Texas state constitution. And if I could show you something. This book here is called 51 Imperfect Solutions. It's by a judge on the 6th Court of Appeals in Ohio, Jeffrey Sutton. I actually practice law in the same firm. Oh, there you are. And I want to read, he advocates that we need to pay more attention to state constitutions because there are 51 imperfect solutions out there, state constitutions and also the federal constitutions, which need to work together in order to create a vibrant area of law. And most state courts, appellate courts, when there's a claim, a federal constitutional claim and a state constitutional claim, they decide the federal constitutional claim, and then they said, well, the state claim's the same. And his argument is that's wrong, that you should really decide on the state constitution independently of the federal constitution. And he refers in this book to lockstepping, and that's where the state courts diminish their own constitution by interpreting them in a reflexive imitation of the federal court's interpretation of the federal constitution. Just because you have certain rights under the U.S. Constitution doesn't mean that those rights under the state constitution, even if they're the same words, have to be interpreted the same way. You can have an independent basis under your state constitution for, particularly in the area of civil rights, for interpreting the law in a way that's different than the federal constitution. The federal constitution and the Supreme Court of the United States, of course, would be an excellent example. But you really diminish the expertise of state judges typically at the Supreme Court level, but since I'm running for an appellate judge position, if their focus is solely on the U.S. Constitution and just give short shrift to the Texas state constitution or whatever state constitution that particular judge may be ruling under. So that is one key area in which I think I distinguish myself from my opponents. I've thought about this a lot. I've read about it a lot. I happen to know him, this judge. He came and spoke before the Federalist Society here in Houston, and that's where I got him to sign his book. And he said during his presentation, if you're running for a judgeship in Texas, you should definitely advocate for the Texas Constitution first before you turn to the federal Constitution. I read through his book and I said, well, you know, I think he's right. And I think it's something that we all as citizens should expect of our justices. So anyway, I don't see the time, so I don't know how long I'm into it.
Okay, a little long.
So anyway, my website will be going up shortly. It's Meyer, M-E-Y-E-R, for Judge, J-U-D-G-E.com. One thing I noticed when I visited the judges over the Court of Appeals, they prefer not to be called justice. And that's similar to my experience when I worked at the Ohio Supreme Court. The justices prefer to be called judge. And to me, the title of judge is as honorary as husband and father, and well, maybe not as honorary as those, but it's up there. And on the campaign trail, I find it hard to say that I'm running for Chief Justice, even though that is the position that's open. Most lawyers even don't realize that we select our Chief Justice by election. We don't select it by the other justices getting together and saying, it's your turn to be Chief Justice. Whether that's good or bad, I don't know. It is what it is, and that's the position I'm running for. So if anyone has any questions, feel free to contact me. I'll even give you on video my office number, which is 281-296-1680, 281-296-1680. Ask to speak to Chuck Meyer, and I'll be happy to answer any questions you have.
Very good. Appreciate you coming in.
No problem. Thank you.
Good luck.